Hey everyone, I'm in Footstep Library at University of Leeds. Such an interesting name, Footsteps. So apparently the name was given by the generous amount of donation from Leeds alumni to set up this room. So you can see this is the room which can be used for lecture or discussion, and behind there is the library, and this is the Late Law Library at University of Leeds. Okay, so coming back to the lecture itself, so for this topic, we'll be covering on the area of jury, such an interesting area actually, but not many students like to attempt this question in the exam. Probably it's because of so many history to remember, but it's good if you familiarize yourself in the topic of jury system because it's one of the unique characteristic of jury system in United Kingdom because in Malaysia we don't have jury system. So let's start with an introduction. So who are these juries? With regards to the definition itself, when we talk about juries, as you have seen in so many legal drama or TV series, juries are essentially a group of citizens and they are randomly selected but legally won. So, which means the electoral system will produce random names every fortnight, and their names being generated because they are registered voters in England. So these citizens are sworn to inquire into any matter of fact. So which means they don't look at area of law just based on what are the facts and also arguments presented by the prosecutions and defendants and give their verdicts either unanimously or by majority of 10 people. So this is an interesting area of law because in the past, juries need to give unanimous verdict, which means all 12 of the jury members need to either give a verdict guilty or not guilty. But because of the difficulties in obtaining unanimous vote, so they have included a definition whereby if you can achieve majority of 10 votes, so court will take into account the verdict given by the jury. So, in the slides itself, never mentioned how many juries need to be selected for one particular trial. Essentially, there needs to be 12 juries to be selected in one particular case to decide on whether that defendant is guilty or not guilty. So remember, 12. So as I mentioned just now, because jury system is considered as one of the unique characteristic of English legal system, so it's good for you to understand the history of jury system itself. So the concept of jury system goes way back since the ancient times, particularly after the Norman conquest, because there are so many criminal cases and it needs to be deliberated by the peers in order to give a fair and just outcome. But in those days, it doesn't immediately start off with the jury system right after the Norman conquest. We look at the year 1215 itself, two important events occurred because before 1215, they adopted a trial called trial by ordeal, which means if someone is accused of committing a crime, so what they do is that they torture you. So they either burn you, or they put knives on your palm, or they choke you, or ask you to walk on fire. So it's literally torture, and if you're still alive by at the end of the day, with the power of God, it shows that you're innocent. But of course, in most circumstances, people die. So because of that, it has been condemned by Pope Innocent III. So which means the Pope mentioned no more trial by ordeal because it's technically against human rights. You're torturing people. People, they cannot present any evidence to show that they're innocent. And on that year itself, the Magna Carta was drafted to include recognition by trial by peers. So no longer people being tortured, but the accused person are given given the opportunity actually to call up their neighbors, their family members to just testify on their characters that they are a good person. So under Henry II, jury began to take an important function on giving out events with regards to they knew in terms of the surrounding characteristic of a person, deliberate on evidence produced by parties with regards to the dispute. So ever since those two events, it has attained or acquired such an importance that Lord Devlin himself wrote in 1956 that trial by jury is more than important when it comes to instrument of justice. It's more than a will of the Constitution. It's the lamp that shows freedom lives. If you can remember this quote, it's very good for you to write in your essay in the final examination because it shows that you remember the history and also a quote provided by Lord Devlin. So these are the roles of juries in order to define this in order to decide on the matter of fact or matter of law decided by the judge. So juries can sit in Crown Court to listen to criminal cases, and in some circumstances, jury can sit in county court to hear on civil cases, but not all civil cases, only limited to four types. So as you can see on the slide, for type of cases that juries can hear in the Crown Court would include serious criminal cases such as murder, manslaughter, rape, gang rape, or burglary. Whereas with regards to county court or jury sits in high court, can only hear defamation, false imprisonment, malicious prosecution, and fraud cases, only limited to these four cases. So in Crown Court, the role of jury is to decide on a matter of fact and subsequently come up with a decision whether the accused person is guilty or not guilty. The judges will decide on the matter of law. Whereas in county court, because it's civil matter, there's no guilty or not guilty person. So juries will decide on the liability, or we call it the quantum of damages when it comes to civil cases. So the number of juries for Crown Court needs to be 12, and whereas for County Court, in High Court, it will be 12 juries, and in County Court will be 8 juries. So I've also included a section on Coroner's Court. So juries can be also selected in order to determine death that occur in prison. Very interesting indeed. So the role of the juries in Coroner's Court is only to decide on the cause of death. So nothing to do with guilty or not guilty. So these are the extensive elaboration on the role of juries in civil cases. I've included 4 cases here. For example, the case of Ward and James, Sink and London Underground, H and Ministry of Defence, McDonald Corporation, and Steele and Morris. So please do familiarize yourself with all these 4 cases with regards to role of juries in civil cases, because these are the examples where parties request for trial by juries in civil cases, and depending on the circumstances of the case, judges would grant trial by juries, or in some circumstances, court will reserve, say, no trial by juries because of the complexity of the case. So with regards to juries in criminal cases, trial by jury is only limited to cases where accused is tried on indictment. Indictment essentially means serious crime. So if you're talking about someone stealing a bread, so you don't have trial by juries because it's not a serious crime. Serious crime would include murder, manslaughter, rape, burglary, all of that. And where the accused person has pleaded not guilty. So if a person has pleaded guilty, so straight away the judges will decide on sentencing. So you'll skip the jury trial itself. So it saves time and saves costs. So jury's role is only limited to facts, of course, because if you want jury to do law, then you need to select juries who have a law degree, so which will become very difficult. So jury will only consider the verdict at the close of the case after the prosecution and defense have presented their case. So the jury in the past must come out with a unanimous verdict, which means 12 out of 12. So sometimes when jury gives a certain decision, there are instances where judges are unhappy with the decision, but judges must accept the verdict given by the jury even the judge disagrees with the outcome. So an example of that happened was in the Bushell's case back in 1670. So, what is the problem with unanimous verdict? Because, as I mentioned earlier, it is difficult to obtain 12 out of 12 decision. So, that's where the majority verdict has been introduced, where as long as you can get 11 to 1 or 10 to 2, majority 10, then it's sufficient. The judge can accept the verdict, either guilty or not guilty. So this is the slide on the selection of juries because not everyone can get the opportunity to become a jury. So it can be an opportunity or it can be a burden. So it depends on how you view it. Prior to 1972, so this is a very important history that you need to remember, a juror needs to be a property owner. So what's the problem with this? There are so many problems with that. If you need a jury to have a property owner, which means even if you are intelligent, if you're above the age of 30 or you very wise person, if you don't have a property, then you cannot become a jury. So in most circumstances, those who can own a property would be one, male, two, middle class, and three, it's either wealthy or old people, I suppose. Yeah. So this requirement was revised in 1972 following the Morris Committee report on jury service because in order for you to promote fairness, you can't have juries in the all male sits in the panel or all middle class that sits in the panel or all wealthy people that sits on the panel. So it wouldn't be fair if the accused person is a woman or if the accused person is let's say for example Asian. So in order to promote more fairness and balance and just outcome, so you need to have a variety of people that sits as a jury in the jury stand itself. So Criminal Justice Act 1972 provided that registered voters were qualified to serve as jurors. So this qualification, and in addition to Section 1 of Juries Act and Criminal Justice Act 2003, specify that to be qualified to be a jury, so a person must be at the age of 18 to 70, which means you're above the age of majority. If you're 16 or 70, you're not qualified. If you're above the age of 70 years old, also you're not qualified. Secondly, you must register as a voter. Thirdly, you must have you must have been a resident in the United Kingdom at least 5 years since your 15th birthday. And lastly, you must not be disqualified from jury service. For example, if you've been served in a prison before, or if you mentally disabled. Some in certain situation, the a person who can be selected might ended up being blind or deaf or just mentally unsound. So in these categories, not qualified to become a jury. So this is the list of those who have been disqualified from jury services, which means if you're a person on bail, if you receive the sentence of imprisonment for life, if you've been detained, imprisoned for public protection, if you receive an extended sentence, or imprisonment for 5 years. So these are the categories where a person cannot become a jury. So you need to remember the selection of juries. You need to remember Section 1 Juries Act and Criminal Justice Act. And it's good to remember the history also with regards previously juries need to be a property owner. But nowadays, if you fulfill this requirement, then you're entitled to become a jury. So this is the example where I mentioned that in some circumstances where the jury is deaf, then it become part of lack of capacity for a person to serve as a juror. So which means in that circumstances, the person cannot sit as a jury. Yes. So some of you may ask why in some countries they have a jury system and why some countries abolish jury system. So let's look at the benefits of having a jury trial. Because if you have a jury trial and your life or the outcome of the trial is decided by your peers, so it increases public's confidence in the legal system in that particular country. So you also have one reason is with regards to jury equity, is that juries are not bound by the doctrine of binding precedent. So essentially, they decide based on the facts and circumstances of the case, because sometimes when people do certain crimes, they have their personal reasons. For example, in the case of R and Owen, where a truck driver was found guilty of drink and driving, causing the death of Mr. Owen's son. So then Mr. Owen, uh, when the truck driver was released from the prison, Mr. Owen became aware that he's continued driving recklessly. So Mr. Owen got a gun and shot the truck driver. So then the truck driver died. So that's why this is the case R against Owen, because he killed the truck driver. But because of the nature of the case and then the reason why he shot the truck driver, the jury felt that he shouldn't receive any imprisonment. So he was acquitted by the jury for any wrongdoing. So this serves the equity part on the by the jury itself. Some say that it's not good because he has actually committed a murder, and the truck driver has actually did his sentence. But then, that's one part, one benefit of the jury system, because jury understands where you come from. So you also have benefits of open system of justice, where members of the public are being part of the legal system. So jury is also protected from any pressure. So they literally decide on the verdict of the case based on the facts presented. So that's where the role of lawyers comes in, because as the prosecutor or lawyer defending the accused person, you need to present all facts and everything that you know. So you need to have a good skill as a lawyer in order to persuade the juries. And lastly is about impartiality, because juries are randomly selected and they represent a cross section of the society as a whole. So which means you have a mixture of Asian, African, local people, young, the variety of age that sits as juries to hear the particular matter. But in some circumstances, of course, there are disadvantages of jury trial itself, because, like in the case of R and Owen, it doesn't make sense. Mr. Owen killed someone, but he was acquitted. So, because of the perverse decision, it's not good in the eyes of the public, because you letting someone who have committed a crime out in the members of the public and have no remorse, or maybe to be part of this society. So it's not good. Uh, with regards to the secrecy, because whatever happens or discussed between the members of the juries in the room, no one knows. So it could be that they have deliberated on the matter of fact. It could be they have been playing Uno cards. They could have done anything. So people not sure how they come up with the decision to determine if a person is guilty or not guilty. So there are also racial biasness in the jury system itself, because even though it represents cross section of a society, sometimes a person can have a negative perception of women or men or Asian. So because of the discrimination that happens, it could be because of his or her personal perception, he's giving a decision of guilty, for example. And also, there is this one criticism that juries are unable to understand complex cases. So perhaps because the case is too complex, jury just want the case to finish altogether. Then they will just take a vote. Okay, who says guilty or who says not guilty. So that's why in civil cases, it's only limited to 4 circumstances, and juries cannot sit in a lot of civil cases, because sometimes it can be very technical for juries to understand. Yep, that's all for this lesson. Please do attend classes, because there are many more that will be covered under the topic of jury, and do familiarize yourself, because it is a very interesting area for you to learn. Thank you.